Mr. Williams, can you state your name for the record, please?
Timothy standing before the court as a state citizen and not U.S. citizen. My nationality.
Welcome back to the courtroom, folks, and buckle up, because today we're stepping straight into sovereign citizen territory. Our main character? Timothy Talley Williams, a man who proudly identifies as a state citizen, not a U.S. citizen. Translation: he's about to test every ounce of patience this judge has. From default judgments in criminal court to citing welfare cases about driver's licenses, it's a legal roller coaster you don't want to miss. In today's hearing, we'll watch Timothy go head-to-head with the court as he challenges basic traffic laws, tries to serve the judge, and recites misinterpreted Supreme Court cases like a greatest hits album of pseudo-law. Stay with us, things get strange.
Mr. Williams, who's representing himself. It's okay, Attorney Vinik. He's representing himself.
Thank you.
You're welcome. All right, Mr. Williams, can you state your name for the record, please?
Timothy for the record, here by special visitation.
All right, and this is the date and time set for a final pretrial in this matter. We are scheduled for a jury trial on Monday. Attorney Mason has tendered to the court a witness list in this matter, as well as a special jury instruction served for you to be able to see in this particular matter. And let me ask again for the record, you have the right to have an attorney. Would you like to have an attorney for you in these matters, sir?
Well, for the record, I'm here to serve a default judgment. I serve you, Andy and Mason, the affidavit. Back.
You did, and I'm in receipt. Oh, go ahead. I didn't mean to cut you off. Keep going.
Yes, on the first, and I gave you 15 days. It was 23 days I gave you, and I haven't received a rebuttal. So I served you guys with a default.
I don't know what a default is. So there's no default judgments in criminal matters. These are
where things go off the rails. Williams isn't answering the judge's simple question about whether he wants an attorney. Instead, he's serving a default judgment. In civil law, that might make sense if someone ignores a lawsuit. But in criminal law? It's nonsense. There's no defaulting on a DUI or driving without license charge. The judge tries to stay calm, gently reminding him that this is not a contract dispute, it's a criminal proceeding. But Williams keeps doubling down, convinced the court owes him an imaginary win. At this point, the judge's patience deserves a standing ovation.
To place is your failure to answer for a ticket. Once it's established and it's here, I don't have to establish why these are tickets on the docket. That's why they have the jury and the bench trial options for you. These have been matters that have been, unless there's been a motion about a formally written motion about illegal stop or some constitutional violation, these tickets are considered to be valid and true.
No, I answered the affidavit of non-corporate existence.
So Mr. Williams, the answer to the question today is whether you're going to trial on Monday or not. That's all I'm here for.
Well, you guys haven't rebutted my affidavit.
Mr. Williams, again, I'm going to say, Mr. Williams, again, the question for today is whether you're going to trial on Monday or not. That's all. I have officers present. I have officers Evans present. I have Officer McCree present. I don't know if Officer Bush is coming as well, but they are here today to know whether or not they're going to be ready for trial on Monday. We set this jury trial out a long time ago for this trial on Monday. So are we going to trial?
Officers? What officer?
We have Officer Evans and Officer McCree present today.
And Judge, I have Officer Nunley. He's trying to check in right now. Faison Nunley.
Officer Bush is here also.
Thank you, Officer Bush.
Good
I didn't see. Good morning. Oh, it's Evans Williams. Okay, say thank you, Officer Bush.
Okay, we go to trial.
Okay, so Monday we go to trial. Do you have a witness list or no, it's just you?
The judge's tone here, patient but firm. She's trying to clarify whether Williams is ready for trial, while he's busy arguing over paperwork that doesn't exist. Meanwhile, officers are lining up, witness lists are being read, and the courtroom is operating in reality, except for Mr. Williams. he still insists that his self-written affidavit of non-corporate existence trumps state law. Spoiler, it doesn't. This back and forth shows exactly why courts dread sovereign citizen defendants. Every question becomes a philosophical debate about imaginary jurisdiction.
Drive unregistered, untitled motor vehicle and drove while unlicensed. And a no proof of insurance. That's one officer. The next officers are open alcohol driver, tinted windows, no seat belt, no driver's license, no insurance, untitled motor vehicle. And then the final officer is going to be drive unregistered motor vehicle, no insurance, no license ever acquired, and tinted windows. Okay.
And Your Honor, if I may interject, since he does have an email, I can copy those tickets and email them over to him
Please.
so that he can have them. I'll come down and
Thank
get those. And I will
appreciate
email
it.
those tickets over to you, Mr. Williams.
Okay.
So that way
And
you can see what
for the
the
record,
tickets
are we able to argue these matters right now, or are we going to trial? Is
You
it
said
possible
you
we
want to
can-
have a trial. What you want to argue?
Yeah,
You
but
want
I'm
to talk
saying,
to
like,
Attorney Mason?
What was that?
I said you want to talk to Attorney Mason just briefly in a breakout room and see if y'all can resolve any of the tickets.
Well, we was just emailing, and I don't know if it meant anything to her, so that's why I'm willing to just take it to trial. And
Well, because you can't say I just want you to dismiss it because I'm not a citizen. That's not gonna work. Or I just want you
Oh
to
no,
dismiss
that's not it. I got laws stating that all this is frivolous, but I'm saying, can we argue this right now, or do we?
A lot of people will say the laws are frivolous. Well, yes, if you have some argument that you would like to make, you can make it that way. I can rule, and that way we can go to, if we're gonna move forward to trial, we can go to trial. Yes, Attorney Soroki.
Yeah, if you like, I can speak to Mr. Timothy Williams in a breakout room for a few minutes, explain the legal system to him.
Yes, can you?
No, sir.
Do you want to make your argument first, Mr. Williams, or do you want Attorney Soroki? Just he wants to give you a little feedback. That way you'll be prepared for Monday's trial. No.
Here it is, the Sovereign Citizen Classic. He's not just defending himself, he's actually trying to sue the judge right in the middle of his own hearing. His theory? Since the court didn't respond to his paperwork, it's automatically in default. In his alternate legal universe, he's the plaintiff, the defendant, and the prosecutor all at once. The actual prosecutor, Attorney Mason, keeps a straight face while the judge calmly resets the train on the tracks. You can practically feel the room exhaling in
Chiku Mason, City of Detroit, 43471.
All right, Mr. Williams.
Yes, Timothy before the court, hereby special appearance as a state citizen, not a U.S. citizen.
Okay. Changes every time. All right, you want to make a motion or you want to make an argument as to these tickets? You can go ahead at this time, Mr. Williams.
Okay, for the record, hold on. For the record, Shapiro versus Thompson states that all citizens must be free to travel throughout the United States, uninhibited by statutes, rules, or regulations, which unreasonable burden or restrict movement. Did you get that?
I'm listening. I'm just writing down. You see, I got my notepad.
Okay.
I'm writing down notes.
And then Murdoch versus Pennsylvania, the Supreme Court decided that a state cannot arbitrarily or erroneously convert a secure liberty, in this case, the secure right to travel, into a privilege and charge of or issue a hold on. A state can't arbitrarily or erroneously convert a secure liberty into a privilege and issue a license and a fee for it, meaning we don't need license or insurance to travel throughout the land. And Murdoch versus Pennsylvania states No state converts security liberty to a privilege. No, Shuttlesworth versus Pennsylvania. No, Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity if you happen to have a license. And back to Murdoch versus Pennsylvania. No state may convert a secure liberty into a privilege. So no state has a right to require you to have a license.
The infamous special appearance, a phrase sovereign citizens love. They believe that by declaring this, they can participate in court without accepting jurisdiction. In reality, it does absolutely nothing. The judge knows it. The prosecutor knows it. Everyone knows it except Mr. Williams. What's fascinating is the judge's composure. She lets him speak, jotting notes, humoring each misquote of case law. If courtroom patience were an Olympic sport, she'd be gold medal.
You to have a license
Required.
because it's a constitutional right to travel.
Which is our First Amendment.
So this right to travel was about a welfare case, Mr. Williams, where she wanted to go to a different state, and they told her that because she didn't have established residency in that she was going to be denied services.
Right, and that violated her.
Right, because it's talking
Right to
about
travel.
services. She needed to take care of her child. She was 19 and she was pregnant.
But you avoiding the effects of the case. Even though that she filed a lawsuit against the state for denying her privileges, but the Supreme Court ruled that the Supreme Court ruled that can't happen because that also be violating her right to travel throughout the states, throughout the land.
Receive the benefits that she needs in order to take care of herself and her child.
Yes, but you're missing the argument that the Supreme Court has stated. That'll be violating her First Amendment right. Life, liberty.
Copy and paste law school phase. Williams starts citing Shapiro versus Thompson, Murdoch versus Pennsylvania, and Shuttlesworth versus Birmingham, famous Supreme Court cases that have absolutely nothing to do with driver's licenses. He argues they prove the right to travel means you don't need registration or insurance. In reality, Shapiro was about welfare benefits and interstate travel, not driving. It's like quoting a housing case to get out of a speeding ticket. The judge listens carefully, writing notes, but you can tell she's preparing a gentle but thorough legal reality.
1995, with Anderson versus Green, California Welfare and Interstate Code annotated section instituted a 1-year residency requirement for welfare aid, violating Shapiro versus Thompson. Both lower courts in California affirmed that violated Shapiro versus Thompson and granted the injunction. I'm sorry. Due to the procedural issue, California's residency requirement never went into effect, creating no justifiable controversy action and no actual issuance for the court to rule on. Whether they receive a waiver from the Secretary of Health or Human Services to set aside Shapiro versus Thompson, making the residency requirement pseudo-legal, the waiver was challenged again, and it's holding that the state court and the Secretary of HHS had not adequately considered public comment on the issues. So this just talks solely about, even talks about the social impact. The social impact and the legal impact is that you can go different places, and we as the governments of each state still have a requirement to take care of those citizens within our state. This is about welfare. Yeah, this is about the welfare system and the ability for people. You cannot stop people from traveling. I don't see anything in here about a driver's license.
Look, the decision of the court.
Right, she has the right to go places.
Look, the court reaffirmed the right to travel under the 14th Amendment Privilege and Immunities Clause in Suez versus Roe. So they conferred it to another case. But the conclusion of the case, like
the judge shines. Instead of ridiculing him, she calmly explains why his interpretation is wrong. She clarifies that Shapiro versus Thompson was about access to welfare services, not about driver's licenses, and that constitutional rights can have reasonable regulations, like licensing for public safety. It's a teaching moment, handled with precision and restraint. She even ties it back to modern rulings, explaining how states can enforce stricter rules as long as they don't violate fundamental rights. It's part courtroom, part civics lesson, and all profession.
She has to establish some type of residency. And what they're saying is that if she doesn't have that residency, she wouldn't get the services needed. And so they're saying you can't say, oh, you can't go to this state and not get the stuff that you need to take care of yourself and your family just because you're not. I can't stop her. I can't say you can't move to this state and then we're going to block everything. I can't do that. Right. This is not about a license.
Which will violate the right to travel.
No.
That was the decision of the court. I'm not making it up.
You aren't, but you're not understanding what their decision was based on. Yes, you have the right to travel, but this is concerning services.
So if I chose to carry a weapon, I will be bearing arms.
If you chose to carry a weapon in the state of in Illinois, that's an automatic. You're not allowed to carry weapons at all in the state of Illinois unless you're a law enforcement officer. So if you traveled over the state lines and you went to Illinois and you tried to carry a gun, they would tell you no.
But that's irrelevant, Your Honor. We're talking about the state of Michigan. I have a right to bear arms, but you will call it receiving
exactly.
But the Constitution of Michigan states that I can bear arms, but
because once again, and we had this conversation already, the states can make stuff more, the localities can make stuff, they can, and it's a state law anyways, but they can be harsher than the U.S. Constitution, but they can do something that would take away from the U.S. Constitution. So they're not taking away your right to bear arms. They're just putting parameters around that right. And recently it was challenged at the Court of Appeals when someone tried to say that the people have the right to bear arms and that seeing a bulge or doing stuff like that didn't equate to it. And the Court of Appeals has said and ruled that does give probable cause for an officer to ask about whether or not they have the licensing because the state has determined that they need to have the licensing. So if the state determines that there needs to be a certain licensing in place and that rule or that is violated, then that has to go forward.
But that's kind of
another sovereign citizen showdown where logic met legal fantasy. Despite citing every irrelevant case he could find, Mr. Williams learned that right to travel doesn't mean right to drive unlicensed. The judge's steady explanation turned confusion into clarity and made this one of the most composed courtroom exchanges we've seen in a while. So what do you think? Was the judge too patient or just right? Drop your thoughts in the comments below.